Right, we are now starting with study unit 5, dealing with the business rescue practitioner qualifications and appointment. Now, just to recap, when business rescue proceedings are commenced by way of a board resolution, then the practitioner is appointed by the board. This must, in terms of the Act, must be done within 5 business days. But as you have seen, as a result of the Panama Properties versus Nell judgment, even if it doesn't happen within 5 days, although the resolution may lapse, that will not mean the end of the business rescue unless somebody applies to court for the resolution to be set aside. If the business rescue is commenced by an order of court, the court appoints an interim practitioner nominated by the applicant, but this is subject to ratification by the majority of independent creditors at the first meeting of creditors. And this is important because it is really the only instance where a practitioner can be removed without a court order. So that is the only opportunity that creditors have if they don't like the practitioner appointed by the court and nominated by the applicant. If they want somebody else, then this is the only chance they have to say, we're not going to ratify this appointment and we're appointing an alternative. After that, if you want to remove the business rescue practitioner, it can only be done by way of an application to court. Qualifications, well, one of the points of criticism against judicial management was that the judicial manager was not required to have any specific qualifications or professional affiliation, and there was no provision for the removal of a judicial manager. Now, the Department of Trade and Industry, while drafting the Act, they wanted to create a special profession for business rescue practitioners, but this failed because that needed a regulatory authority, and a regulatory authority can only be created by statute, and that was not done, not in the Act of in the Companies Act or any other. And so they went for the alternative, which is very close to what we have, what you see in England. In other words, where the practitioner has to be licensed by a government authority. In England, the licensing can also be by the professional organization of which the insolvency practitioner is a member, but in South Africa, only the CIPC can issue a license, but this is subject to the requirement that the person is a member of an accredited professional body. And that's very important. Initially, there were no accredited professional bodies, so the CIPC simply issued licenses, but they did eventually get round to devising or creating the opportunity for accreditation, and there are now, I think, about 12 or 13 accredited professional bodies. That would be the Legal Practice Council, the Regulatory Authority for Auditors, accountants, etc. So there are quite a few. You can see the list on the CIPC website of the accredited professions or professional bodies. Now it says Section 138 states that a person may be appointed. Now, strictly speaking, the definition of person includes a legal person, but it's clear when you look at the other qualifications that a legal person cannot be appointed, and the CIPC will not license a legal person because the qualifications, many of the qualifications are those for appointment as a director, and a legal person can never be appointed as the director of a company. So the same applies to a business rescue practitioner. There has to be one specific person who takes responsibility. although most of them work in companies or firms with a whole team of people. Right. Then there is a list of 6 qualifications for appointment as a business rescue practitioner. But when you look at them, they are really disqualifications rather than qualifications. The first one is then that you must be a member in good standing of a legal, accounting or business management profession accredited by the Commission, which we've just talked about, and then be licensed by the Commission. And you have to apply to the Commission to be licensed. They have guidelines on their website on exactly what documentation they require, and how the process works. And then if you are licensed, I think the license is valid for a period of 3 years at the moment. Then the CIPC may withdraw or suspend the license. For instance, if you fail to submit the monthly progress report, because then you no longer meet if you no longer meet the requirements of Section 138 if you are not licensed. However, not being licensed does not automatically remove the business rescue practitioner from the appointment. There still has to be an application to court to remove this practitioner on the grounds that this practitioner no longer meets the requirements of Section 138. And unfortunately, the CIPC has not been given the power to apply for such an order. It has to be done by an affected person. So the CIPC, even though they may be aware of the fact that the practitioner no longer meets the requirements and is perhaps no longer licensed, they cannot apply for the removal of this practitioner. Okay, then, so when you look at Regulation 127, the restriction on practice, what this regulation provides is that all licensed practitioners are classified based on the period that they have been actively engaged in business turnaround practice. Now, there is a definition of business rescue, business turnaround practice, which is wider than business rescue, and that was really to solve the problem when the Act was newer than 10 years. So the Act had not been in force for 10 years, so it was impossible to have 10 years or earlier 5 years practice in specifically as a business rescue practitioner. So it's wider than that. Now, of course, the Act is already 11 years old, but if you have been engaged in other forms of business turnaround practice, you could perhaps still be classified on the basis of that experience. So a senior practitioner is somebody who has at least 10 years of turnaround practice experience. And this person can be appointed for any company, including a state-owned company. An experienced practitioner must have at least 5 years. This person can be appointed as practitioner for a medium or a small company, but not for a large company and also not for a state-owned company. Junior practitioner is then less than 5 years experience, and they're down to none. Such a person can only be a practitioner for small companies, except as the assistant to a higher ranking practitioner for other companies, but not on his or her own. And this classification of companies is done in terms of according to the company's public interest score, as regulated in Regulation 26.2. In other words, based on number of employees, turnover, etc., etc. That's all in Regulation 127, and that will give you the size of the company, whether it's large, medium, or small, and that will then determine who can be appointed as the business rescue practitioner of that company. Okay, so the other qualifications, as I said, they're more disqualifications than qualifications. which is a pity because they should have actually gone to the trouble of coming up with very specific qualifications for business rescue practitioners. This person must not be subject to an order of probation. Now, the Act simply says you must not be subject to an order of probation. Usually, an order of probation only lasts 5 years, and it may be limited. The order may say you're not allowed to be a director of a public company, but only of a private company with fewer than 20 members or whatever. It doesn't seem as if that limitation will apply in the case of a business rescue practitioner. So any order of probation will disqualify a person from appointment as a business rescue practitioner. Then you must not be disqualified from acting as a director in terms of Section 69(8). Now, Section 69 distinguishes between ineligible persons for appointment, such as a juristic person. So obviously that will also apply. And then disqualified. And that's what the section refers to. And that's where there's a delinquency order out on this against this person, or the person is an unrehabilitated insolvent, or has been removed from an office of trust. So you can look at Section 69(8) to see on what grounds a person will be disqualified from acting as a director, because such a person will also be disqualified from being appointed as a business rescue practitioner. The next requirement is that this person must be independent from the company. The Act has a rather convoluted wording for this requirement, but that's basically what it comes down to, that the person must be independent from the company. And then the person must also not be related to a person who has such a relationship. Well, related is defined in Section 2.1, and that means married to that person or related within 2 degrees of relationship. In other words, being family of that person. Now, you'll see there's an extract from the 2022 Deloitte Restructuring Survey, where they surveyed business rescue practitioners, companies, directors, auditors, etc., and big creditors, in other words, lenders, mostly financial institutions. And this is what the report says about the survey on business rescue practitioners. What is evident is that there is a widening trust gap between practitioners and their stakeholders. Low success rates contribute to this. The suitability of the business rescue practitioner is also rated as one of the main reasons that business rescue fails, ranking closely behind a lack of post-commencement financing. While the adage of the past was no post-commencement financing, no business rescue, perhaps this needs to change to reputable business rescue practitioner, successful rescue. And that is in fact so because the lenders or the banks, etc., who are prepared to give post-commencement finance will only do so if they are familiar with the business rescue practitioner and they trust the person who has been appointed as the business rescue practitioner. And then there's another statement in this survey. It's a quote from a business rescue practitioner stating that the problem is that many BRPs lack the skill and ethics to do it properly. So that is a serious allegation against some business rescue practitioners. Right, then removal of the practitioner. Now, first of all, it can only be done by way of a court order. You cannot remove a practitioner in any way except for that first meeting of creditors in the case of commencement by court order. Now, we've already talked about the possibility of removing a practitioner in terms of Section 130. In other words, where there was commencement by way of board resolution. but this can only be done until the business rescue plan has been approved. Section 139(2) also provides for the removal of the business rescue practitioner, and this can be done at any stage of the business rescue. So in terms of Section 130, you have the three specific grounds. The person does not meet the Section 138 requirements, is not independent of the company or management, or lacks the necessary skills for the particular company, although this is not a requirement for appointment, but you can be removed on that ground. Then removal in terms of Section 139, where you can use at any stage. And here there are more grounds for removal. It's incompetence or failure to perform duties, failure to exercise the proper degree of care, engaging in illegal acts or conduct, Section 138(1) requirements not met. There's a conflict of interest or lack of independence, and then incapacitated and unable to perform functions. That's where the person becomes very ill. For some reason cannot perform his or her functions. Now, as far as the conflict of interest is concerned, I think in your study guide, there is a discussion of the application in OPA Investments versus Tegeta, where there was an application for removal of the business rescue practitioners because it was alleged that they had a conflict of interest because they were appointed as practitioners for two companies in the same group, and these companies had claims against each other. But the court found that this in itself, just being business rescue practitioners for two companies in the same group, in itself, that's not a conflict of interest. And on appeal, it was confirmed that what is important is the Supreme Court of Appeal said that the grounds for removal are personal to the business rescue practitioner. So we're not talking about a conflict of interest between two companies in a group where you have the same practitioners. It is a conflict, a personal conflict, or a conflict between the personal interests of the business rescue practitioner and those of the company. So it doesn't really apply to companies. So a conflict of interest between two companies is probably not what we find within this section. And apart from that, a potential conflict is not enough. There was no evidence that there had, in fact, been a conflict of interest. Now, there was another judgment by the full bench of Gauteng High Court, where the practitioners were in fact removed, but you will see that this was overturned on appeal, and where the High Court relied, among other things, on the fact that the practitioner is an officer of the court, so they made a big thing out of that. The Supreme Court of Appeal said that really, apart from the fact that the decision was not really supported by evidence, there was no real evidence of breach of fiduciary duties or breach of specific duties, but also as the Supreme Court of Appeal said, this provision that business rescue practitioners are officers of the court, this provision is actually meaningless, because in most cases where there's the court is not involved in the business rescue process, and it was specifically intended like that by the drafters. So how can you call them? It doesn't really matter whether you call them officers of the court or not. It doesn't really add anything to their duties. And the requirement that they must report to court, in most cases, especially where the business rescue is commenced by way of a resolution of the board, the court has nothing to do with this whole thing. So how can they report to the court, and where do they report to the court? So that is not really of any value. Then you will see in your study guide, there is also a discussion of the case of Tayop versus Shiva uranium. And that was all about the replacement of a business rescue practitioner. Now, this is again one of the very confusing provisions in the Act. Section 139(3) states that the company or creditor who nominated the previous practitioner must appoint a new practitioner if the practitioner dies, resigns, or is removed from office. Now, first of all, nowhere else in the whole of Chapter 6 is there any mention of resignation by a business rescue practitioner. There is no indication that a business rescue practitioner may resign, on what grounds, how, what procedure must be followed, who must be notified. Nothing. This is the only subsection or section where the one word resigns can be found. But we must assume that with that one word, the drafters actually meant to indicate that a business rescue practitioner may resign. The question then is, who appoints the replacement practitioner? Now, in terms of Section 130, Section 130 states that the person must be recommended by or acceptable to independent creditors represented, where there's an application in terms of Section 130 to remove the practitioner. In Section 139, 3, it says, the Section 100, in the case of an application for removal, the creditor who nominated the previous practitioner, the company or creditor who nominated the previous practitioner. And this actually refers to removal both in terms of Section 130 and Section 139. So how do you consolidate these two, where Section 130 says recommended by or acceptable to independent creditors, but in terms of Section 139, even if the removal is in terms of 130, the replacement practitioner must be appointed by the company or creditor who nominated the original practitioner. So in your study guides, there is a discussion of the Supreme Court of Appeal judgment in Tayop versus Shiva uranium, where the question was who has the power to appoint the replacement practitioner where a practitioner resigns, because the business rescue practitioners were of the view that they had the right to replace or to appoint or nominate the replacement. And the company said, no, we have the right, the board, we have the right to appoint the replacement. The Supreme Court of Appeal said that in terms of Section 139(3), the board of directors must appoint the new practitioner, and this power is not subject to the authority or approval of the resigning or any remaining business rescue practitioner. So if you resign, you cannot nominate your successor. If there's a remaining practitioner, he or she can also not appoint the successor. It would be the original. If it was the company, then the board has the right to appoint the new successor or the new business rescue practitioner. And this has now been confirmed by the Constitutional Court. The Constitutional Court said it depends on whether the original or the resigning or removed practitioner was nominated by the company or the creditor or appointed, and that the company or the creditor who nominated or appointed the previous practitioner has the right to appoint the replacement. So after resignation of the previous practitioner or practitioners, the board has the right. If the board appointed the first practitioner, then the board now has the right to appoint the successor to the resigning practitioner. So that at least has now been confirmed and sorted. It won't end all the problems, of course, but at least there is certainty about who has the right to do this appointment. Okay, management powers and duties. I'm not going to discuss in too much detail. What is important, however, is that the practitioner takes over management control of the company in substitution for its board and pre-existing management. So although the board is still in place, they have to act under in terms of the instructions of the business rescue practitioner. The practitioner may remove from office a person who formed part of the previous management, but we're not sure whether that, it probably only means remove from office, but that person will still be an employee of the company. And may appoint a person as part of management, fine, there is no problem with that, that's fairly clear. The business rescue practitioner may not remove directors from office or appoint directors. To remove a director from office, the business practitioner will have to apply to court and on specified grounds, and these all have to do with a director who is proving to be a problem in the business rescue, in other words, obstructing the business rescue practitioner in the exercise of his duties. So that it's very specifically restricted to that. And the practitioner can also not appoint a new director. Here again, officer of the court, you still find courts referring to the fact that the practitioner is an officer of the court, although the Supreme Court of Appeal and the Supreme Court of Appeal basically said it's meaningless. Now, and then, of course, the very important duty of the business rescue practitioner is to develop a business rescue plan and implement this plan if it is adopted, and he or she may not be appointed as liquidator if the company is liquidated. The practitioner must investigate the affairs of the company. It doesn't really mean much to say he must investigate, because there's not much he can do except if the practitioner at any point comes to the conclusion that the company does not have a reasonable prospect of being rescued, then the practitioner is obliged to inform the court, the company, and affected persons, and must apply to court for the business rescue to be discontinued and for the company to be put into liquidation. That's an absolute obligation. There's no getting away from that. If the company is not financially distressed, well, you could terminate it by court order or by filing of a notice of termination, depending on how it was, the business rescue was initially commenced. Now it says, the Act says rectify voidable transactions. When we see voidable transactions, we immediately think of the dispositions that can be set aside in terms of the Insolvency Act. This is not what this provision refers to. Remember, the drafters were not South Africans. They didn't know that voidable transactions in South African law has a specific meaning. All this means, because there's absolutely no authority anywhere for a business rescue practitioner to set aside transactions. All it refers to is that if the practitioner finds that the company performed certain actions without complying with the necessary statutory requirements, for instance, where a special resolution of shareholders was necessary and they didn't obtain that, then the business rescue practitioner must tell the management to fix that so that they rectify this problem. So that is all it refers to. It's really internal actions that were not valid. And then investigate criminal acts. Well, I don't think much will happen there. I'm not sure where they have to report it, and if they do, whether anybody will be prosecuted. I rather doubt that. Then the liabilities of the practitioner. The practitioner has the responsibilities, duties, and liabilities of a director. The court actually said that in one judgment, I think it's quoted in your study guide, that this was a legislative shortcut, because it's not, you cannot really use the responsibilities and duties of directors for a business rescue practitioner. Firstly, the directors are still there. So the business rescue practitioner is not a director. And secondly, these duties and liabilities don't all fit in with the duties of a practitioner. The legislator should have created duties and liabilities specifically for practitioners. Then the practitioner is liable to the company for loss, costs, and damages caused by a breach of the duties. And then there are other specific grounds. And then the Act says, but the practitioner incurs no other liability unless for anything done not in good faith or grossly negligent. That other the word other means that apart from the previous provision regarding liability, no other, you cannot hold the practitioner liable for any other action unless it was done not in good faith or grossly negligent. But we're not sure, we must assume it's probably to the company, because it's all about the duties and liabilities to the company. Then remuneration. There's an extract from VR Laser Services. I think it's in your study guide as well. This case highlights in acute form the need for creditors and other stakeholders to rein in the BRPs in order to ensure that business rescue is not abused or does not cause considerable harm or does not result in the BRPs being the main beneficiaries of the process. In this case, the business rescue practitioners and their attorneys have earned a considerable amount of money from the business rescue process. So the court was really unhappy about that. Right, so prescribed remuneration. And I still see quite often that business rescue practitioners are not keeping to the prescribed remuneration. Now, their argument is that the fees have not been adapted or increased since the company came into the Companies Act came into operation, but the Act does provide for additional fees or additional remuneration, and you can always use that not to increase the prescribed fees, but to get additional payment. So the tariff of fees is prescribed by the Ministry in Regulation 128. It's based on the size of the company and not on the seniority of the business rescue practitioner. Then we mentioned the Murgatroyd case, and that's where the court held that the business rescue practitioner doesn't have to do everything him or herself. They are allowed to appoint advisors and consultants, especially where it is a complicated case, but it will depend on what is reasonable. But if it is reasonable, then those will be expenses and costs in business rescue. Okay, now, so you have the tariff of fees, which is based on the size of the company. It is X rand per hour, subject to a maximum per day. In addition to that, the business rescue practitioner may come to an agreement with the company for additional remuneration for the achievement of specific results, such as having the business rescue plan approved or something like that, obtaining post-commencement finance, whatever they decide. Now, this is an agreement between the company, in other words, the board and the practitioner, but it is subject to approval by the majority of creditors and the majority of shareholders at meetings called for that purpose. You will see that reference to Opsa versus Golden Dividend. the court said the act is very specific. You have to have meetings of creditors and meetings of shareholders for this specific purpose to approve the additional remuneration. You cannot just stick this additional remuneration in the rescue plan, and then if the creditors vote in favor of the plan, then you say, well, they have now also approved the additional remuneration. It doesn't work that way. So in any case, both the creditors and the shareholders, even shareholders who have absolutely no voting rights on the plan itself, they must approve this additional remuneration. And it must be at a meeting called for that purpose. Now, even if the additional remuneration is approved as prescribed, it is still possible to object against that remuneration. A creditor or shareholder who voted against approval may apply to court within 10 business days after the voting took place for the agreement to be cancelled on one of two grounds. It's not just unequitable, or it is unreasonable having regard to the company's financial situation. So you can 3 points you have to remember. Number one, this additional remuneration provision cannot be used to increase the tariff of fees, because the Act is very clear that the fees, the prescribed fees, must be paid in terms of the Act, and it may not exceed the prescribed amount. So you are stuck with that. But you can come to an agreement for extra remuneration. It must be subject to the performance of a certain or achievement of a certain purpose, and it must be approved by both creditors and shareholders at meetings held for that specific purpose. You could have other items on the agenda as well, but the meeting must specifically also, when you send out the notice of the call of this meeting, creditors and shareholders must be told this is one of the things that you will have to vote on, whether the extra remuneration can be approved or not. And even if it is approved, then you can still go to court and have it set aside. Okay, then we come to the other important point or aspect of business rescue, and that is the preparation of the business rescue plan. There was no provision for any sort of rescue plan in judicial management, and that was regarded as a weakness in the system. There, I think, were certain advantages to not having a plan. It was not so good for the shareholders and the creditors, because they had no idea what the judicial manager, how he was trying to save the company. But it was it was possible for the judicial manager to sort of change course, to go to try something, and then if that doesn't work, or at some point he sees that it is not going to work, then he can actually go to or try something else. With a plan, once the rescue plan has been approved, you will see that the business rescue practitioner is stuck with that plan, and if he wants to change the plan, he or she will have to call a new meeting of creditors and, if applicable, shareholders, and have them vote on a new plan again. You cannot just amend an existing plan once it's been approved. The Act requires the business rescue practitioner to consult with the management of the company, the creditors, and affected persons. The Act is not very clear on how this consultation should take place. In your study guide, there's a reference to the Slumisa case, where the court actually granted an interdict because the affected person said they were not properly consulted. I am not quite convinced whether this is such a strong requirement. I think it's more an informal way of consultation, because the Act doesn't prescribe any specific procedure or the way that this consultation should take place. Then it's also required that if there was an informal proposal by a creditor that is included in the plan, this must also be disclosed. I'm not sure why this is a requirement, because on the one hand, the Act says you must consult with creditors, and then on the other hand, it says, but if there's an informal proposal by a creditor that you take up because that's why you consulted with them, then you must disclose that, as if there is something wrong with consulting or including a proposal by a creditor.